All right, hello everybody. So I've had a couple of questions from students about the easiest way to identify the different branches of law in a problem question. So I've put together this very basic presentation for you, and we're only going to discuss contract, tort, administrative law, and constitutional law. And this is a basic guide only to identify the source of an obligation, the legal question or the issue that you would be discussing in your IRAC analysis, and the usual remedies. But that's going to be very brief in today's presentation. So we're going to start with the source of the legal obligation. So when you have a problem question placed in front of you, if you don't understand where the legal obligation comes from, it is very difficult to then analyze and discuss it. So first we need to find the issue. The issue comes down to the legal obligation. So we have private law and public law. So private law, as it says on the screen, usually regulates relationships between persons and organisations, and this is in contrast to public law, which regulates public power and government institutions. Then we're going to delve down further and we're going to be having a look at the different types. So we've got contract law. This is a promise-based obligation. So what did the parties promise or agree to? Usually they are voluntary assumed obligations in the contract, and the result of this is the enforcement of the bargain or compensation for the breach of the contract. Now, another type of private law is tort law. So we've got contract, we've got tort. And here in the problem question, you are looking for harm. So in a problem question, which would have contract law as the issue, we are looking for a promise between parties. And in a problem question, which would be a tort-based legal problem question, we are looking for some harm that has occurred. So did the law impose a duty to avoid this harm? So this is a duty imposed by law, and the result is compensation for the legally recognised harm from the duty imposed by law. Then for public law, we've got some administrative law. And here we are looking for a decision made. Was the government power exercised lawfully? This will be the most likely problem question issue that would come up. And if you see a government power and someone's questioning whether it's been exercised lawfully or not, that is an administrative decision. We are looking for the source of power, which might be statute, executive power, etc., etc. And the result is a review of the decision. The decision may be set aside or the decision may be remit. So that is administrative law in the problem question. We are looking for a decision and you may be advising the party on what they can do about that decision. Then we also have constitutional law, which is another type of public law. And here we are looking about power. So does the institution possess this power? How would we know that? Does the institution possess the power underneath the Constitution? Here we would be looking for the constitutional text and the principle, and we would also be looking at, so we're looking for constitutional text and principle. These are the sections of the Constitution that grant that power. And then the result would be the law would be declared valid, invalid, or inoperative. So this is a great starting space when you look at a problem question. And please excuse that noise in the background. There are tradies here at the moment. So let's delete all of this and let's keep moving. So let's go a bit of a deeper dive into contract law. So contract law enforces voluntary assumed promises. Now remember, this may be written or unwritten, but the legal relationship begins with agreement. So here, if in a problem question, the court would identify the parties' rights and obligations where? From the contract and the governing law, of course. Now, a useful problem solving sequence for students is I want you to start with the formation of the contract. Here we are looking for agreement, consideration, intention, certainty, promises, etc., etc. Then I'm looking at the terms of the contract. What promises form part of the contract? What was agreed? Then we are looking for performance. Has a party breached a term? Has a party yet to fulfill a term? And then we are looking at the consequences, which is causation, remoteness, and available remedies. So that is contract law. Typical remedies include damages, protecting the contractual performance interest, sometimes specific performance or an injunction, termination, or restitution. Then we're going to look at tort law. So, tort law, we know, imposes duties independently of an agreement. So, you don't need to have a contract to impose a tort law legal obligation. So, tort protects interests recognised by the law, including bodily safety, property, reputation, and use of land. So, negligence in a problem question, you would usually need to ask, is there a duty? So, does the defendant owe the plaintiff a duty of care? Breach, does the conduct fall below the required standard expected? Causation, does the breach cause the harm? So, even if there has been something happening here where the conduct has fallen short, if the breach did not actually cause the harm, then this defendant may not be found liable. Damage, is the loss legally recoverable and within scope? And for example, in the construction industry, we look at things like pure economic loss, etc., etc. So, an example of something you may see: a crane operator carelessly drops material and injures a pedestrian. No agreement between them is required. So there would be no contract between the crane operator and the bypassing pedestrian, but that does not mean that the pedestrian cannot recover damages. And this is an example of a negligence claim. So negligence is only one type of tort. Others include nuisance, trespass, and defamation, but we won't go through all of them today. But it's important to note, tort law is a banner of multiple duties. Then we have administrative law controls, and this controls government decisions. So we are looking in a problem question for the government decisions or decisions made by ministers, departments, regulators, councils, statutory officers, and tribunals. So we are asking about the legality of a decision. So was the decision within the statutory power? Did the individual who made the decision have the authority? Then we are looking for procedure. Was the procedural fairness observed? Did they follow the correct procedure? Reasoning. Were relevant matters considered and improper purposes avoided? And legal limits. Is there jurisdictional error or legal unreasonableness? So an example that you may see in a problem question could be a council refuses a planning permit after considering an irrelevant factor and denying the applicant a fair hearing. This would be an administrative law issue. Typical result, the decision may be set aside and remitted for lawful reconsideration. The court usually does not substitute its preferred decision. Then we have constitutional law, and we know in constitutional law, this is all about who may exercise public power, and it all comes down to what was written in the Constitution. So we know the Constitution creates and constrains institutions in both federal and state and territories. It allocates legislative, executive, and judicial power and regulates the federal system. So an example of something you could see in a problem question, whoops, that's not very nice, but it would be a valid Commonwealth Act conflicts with a state act. What would we do here? Well, we know that Section 109 of the Constitution makes the state law inoperative to the extent of the inconsistency. So the core questions you would be looking at are things like, is a Commonwealth law supported by a constitutional head of power? So can the law actually be made under the Constitutional? How is power divided between the Commonwealth and the states? Has one institution exercised power reserved to another? And does a constitutional limitation or freedom restrict the law? Typical result, a court declares the law valid, invalid, or inoperative to the relevant extent. Now, contract and tort may actually govern the same event for different reasons. So here on the left-hand side, we have contract issues, and I've got their contract issues here. And on the right-hand side, we have tort. So the source is different. So the source under contract is a promise voluntarily assumed by the parties. This is in the contract, verbal or written. And under tort, the source comes from a duty imposed by law. Then under contract, we have the agreement, and this requires an enforceable contract. Under tort, we do not require a contract. The main inquiry or issue might be what was promised and was the promise breached. And under tort, it was a protected interest harmed through a tort. Measure often places the claimant as if the contract were performed, and this tort often restores the claimant to the position had the tort not occurred. Example for you, a builder supplies materials below the agreed specification in the contract, but under tort, it might be that falling material injures a person with no contract. Now, we can have concurrent liability. I'm not going to go into that in today's mini video, but in other lectures, you will discuss concurrent liability. So, for example, if contracted work is performed carelessly, the facts may support both causes of action under contract and under tort. But what will impact whether you go via contract or go via tort will be things like pleading, contractual limits, and legislation affecting the availability of claims and remedies. Now, the public law branches operate at different levels. So we have the Constitution, which creates institutions, allocates, and limits power. Then I want you to take a step down, and we're going into Parliament, which enacts a statute, and the law must remain within that constitutional power. Then we head into administrative law, and this is where the official receives the statutory power, and the decision maker must stay within the power of the statute. And then we have the administrative decision, which is the power must be exercised lawfully and carefully. So in this chain, we have both administrative law and constitutional law issues. But as you'll see, when the issue moves down the chain, so we start at the top with the power to create the law, and we're moving down the chain to when it is actually implemented on the ground. And at this point, we swap from constitutional law to administrative law, which can be a little bit tricky to get your head around. And here's a comparison matrix for problem questions that you might find useful. So it's a brief summary. We've got the branch, we've got the source, typical parties, the central question you might be looking for, and the usual outcome. So on the top line, we have contract law with the agreement in the contract. We are looking for the, sorry, my pencil just disappeared. We are looking for the contracting parties, what was promised and breached, damages or enforcement. In tort, we are going to be looking for a duty imposed by law. There is a person harmed and an alleged wrongdoer. Did a tort cause recoverable harm, and what is the compensation? Then we are moving into our public law, which is the administrative law. Public power, often statutory. We are looking for an affected person and public decision maker. And the real question is, was the power exercised lawfully? The decision may be set aside, there may be a declaration or a remittal. Then we've got another type of public law, which is constitutional law. Here, the question will impact or surround the Constitution. We are looking for governments, institutions, or affected litigants. And does the institution or law possess constitutional authority? Is it valid or invalid? So now what we're going to do is move into identify the source first, then match the parties, issue, and remedy. So the identity of the parties will help you organise the type of law that you need to be talking about, but the source of the alleged obligation is usually more decisive. So we're looking at the parties, but also the sources of the obligation. So this is a problem question for you to work through. There's a couple of them. And if you understand the different types of law, you should be able to very easily look at these particular problems or sentences and understand which branch is the best starting point for your problem question. So I'm going to put all the types on the screen. Then what I want you to do is pause it and have a go at answering it yourself. So A retailer accepts payment for a laptop but fails to deliver it. B, A regulator cancels a professional licence without giving the licensee an opportunity to respond. C. A careless driver runs a red light and injures a cyclist. D. A state act is inconsistent with a valid Commonwealth Act. E. A builder's crane damages a neighbouring cafe with which the builder has no agreement. So at this point, I want you to pause the video and I want you to attempt A to E. Have a guess if you're not sure. Go through the slides if you need to. Go through your notes. Some of these scenarios may engage a second branch, but you would need extra facts in order to make this determination. But as a starting point, I want you to have a think about which type of law may help you solve each of these legal problems. And there may be some extra questions that you need to ask yourself in order to classify the dispute, and I've added these. So a quick decision aid, we need to check, is the dispute about constitutional validity, allocation, or limitation of public power? If it is, it might be constitutional law. Check, is a government decision maker exercising an existing public power? If they are, check, might be administrative law. Check, does the alleged obligation arise from an enforceable agreement? If it does, it might be contract law. And check, does the alleged obligation arise from a duty imposed by law to prevent harm? Check, might be law of torts. So these are some questions that you can ask yourself in order to determine what type of law the problem question may involve. So let's go through the answers. If you have not attempted these, please pause it. This is your final warning. Please pause it and give it a go yourself before you have a look at the answers. So A, a retailer accepts payment for a laptop but fails to deliver it. This would be contract law. The delivery obligation arises from the sales agreement. B, a regulator cancels a professional licence without giving the licensee an opportunity to respond. This would be administrative. The challenge concerns lawful exercise of regulatory power. C, a careless driver runs a red light and injures a cyclist. This would be tort law. The driver owes a law-imposed duty of care to the cyclist and other road users. D, the state act is inconsistent with a valid Commonwealth Act. This would be a constitutional law issue, and we know that Section 109 of the Constitution governs the Commonwealth state inconsistency. E, a builder's crane damages a neighbouring cafe with which the builder has no agreement. E, this would again be tort. No agreement is needed for a duty concerning foreseeable harm. Hope this was helpful, and if you have any further questions about the types of law that you may encounter, please let me know. Thank you.